Okay, we can start. And I give immediately the floor to Professor Alessia Di Pascali, who is in Odysseus the member representing Italy, to whom we quite often ask to enlighten us about the complex situation in Italy, not easy always to understand from abroad. Alessia, the floor is yours.
Thank you, Philippe. I'm truly honored to coordinate the last session of this very interesting conference that in these 2 days has provided us with many foods for thought and investigation for the next 2 years of implementation of the pact. Among the many points raised by the speakers who preceded us, and of which I have taken note, concerns have emerged regarding the mechanism of compliance and monitoring. Doubts have been raised on judicial control and its implementation by member states, not always willing to fully and effectively comply with the indication of the courts. And therefore, the opportunity to support judicial control with other mechanisms of control and complaint has been highlighted. An issue evidently all the more important in relation to the possible violations of fundamental rights. In recent years, we have actually witnessed a strengthening of tools to make migration control more effective with significant legislative intervention, to which supervisory and perhaps reassurance with respect to this choice, this mechanism of respect for human rights have been associated. Coming to the topics that will be specifically addressed by this panel, I'd like to remind that the scope and number of databases and information systems for storing data on regular and irregular entries have been expanded, which obviously raise issues of protection of privacy and also of minors and personal data in relation to minors, where in particular the new Eurodac regulations lowers the age for collection of biometric data to 6 years, although providing for a series of precautions to safeguard the best interest of the child. But it's from the point of view of deterrence and the fight against irregular flows that the most critical profiles emerge with the adoption of a new regulatory apparatus aimed at preventing entries. I'm thinking of the new screening mechanism that was discussed yesterday, the changes, but also the changes to the Schengen Border Code and the contrast against the so-called instrumentalization of migrants. In this regard, under the new rules adopted under the Pact, EU countries must establish adequate mechanisms to monitor compliance with fundamental rights when screening new arrivals and assessing asylum application at the EU's external borders. The 2019 European Border and Coast Guard Regulation has strengthened the fundamental rights protection apparatus by expanding the powers of the Fundamental Rights Officer, supported by observers to monitor individual operation of the agency, providing detailed reporting and improving the effectiveness of the complaint mechanism. Nevertheless, there have been allegations of violations in recent years. But now the overall apparatus is operational and we can question its effective functioning. The Fundamental Rights Agency is carrying out an orientation activity on the various mechanisms for the protection of fundamental rights, in particular with the recent publications of guidelines addressed to the member states for the purpose of preparing national control mechanisms. All these aspects will be discussed by the speakers of this panel, who I mentioned, and describing the innovation in European legislation on immigration and asylum will highlight the most critical aspect and those worthy of being examined in the coming years in relation to this process of control, monitoring and possibly reporting, questioning the real scope and effectiveness of this mechanism and any gaps in the system. So we start with Professor Niovi Pavla, who is associate professor at the University of Luxembourg and who will address Eurodac Generation 3. And the title is Better Controlling Irregular Migration. And please, Professor Pavla, the floor is yours.
Thank you so much for the kind invitation to participate in this so important conference at such an important time. Today, what I would like to present to you is probably the underdog of the Common European Asylum System, in the sense that it is perhaps the most under-researched part of the Common European Asylum System. It has to do with its digitalization. So Eurodac forms part of the bigger family of large-scale IT systems at the same time of being part of the Common European Asylum System. This means that it sits at the same time on two different stools, and it gets affected by the provisions not only of the Common European Asylum System, but also of the different developments that take place in parallel as regards the other databases, some of which are currently operational, like SIS or VIS, but others, such as the entry-exit system, ETIAS and ECRIS-TCN, are scheduled to become operational in the next year, with the aim of becoming fully interoperable, all 6 of them, by 2027. So Eurodac has already undergone a major revision in 2013, which is the current legal basis for the use of the database. It became operational first in 2003 with a primary aim of assisting in the administration of the Dublin system, which remains to date as its primary purpose. But in 2013, the database was also opened up for consultation by law enforcement authorities in Europol for the prevention, detection, and investigation of terrorist offenses and other serious crimes. Compared to the other large-scale IT systems, its personal scope and the categories of personal data are relatively narrow, in the sense that the data that it currently collects concerns primarily applicants for international protection who are fingerprinted if they are above the age of 14, as well as irregular migrants apprehended in connection with irregular border crossing, plus irregular migrants found on national territory. However, that consultation is not mandatory at the moment. The categories of personal data are very limited. A person is primarily defined by their fingerprints. Actually, Eurodac has been the first experiment with biometrics at EU level. And name and nationality are not stored in Eurodac, but there is possibility through Dublinet to exchange data following a hit. So if a person has been identified in another state via their fingerprints. So a person is defined at the moment solely by their fingerprint data. And the detention period is 10 years for applicants for international protection and 2 years for irregular border crossers. For irregular migrants, the data are not stored, therefore there's no retention period. As you can appreciate, because the personal scope of Eurodac involves applicants for international protection, the transfers to third countries are prohibited, and individuals must be provided with information as regards a series of aspects, such as the purpose of processing, the controller, who gets the data, this is an obligation, and other data protection rights that applicants have. So this is just a small taste of how Eurodac operates at the moment, with its problems, because sometimes there is miscategorization of applicants. If someone is an irregular border crosser, may be miscategorized as an applicant for international protection. Or, for instance, there have been issues, especially during the so-called refugee crisis, with the fingerprinting requirement, with states saying, I'm not going to do that anyway, or asylum seekers were burning their fingertips. So Eurodac will substantially change. Under highlight, you can see the major changes, which I will explain in brief before going into the fundamental rights challenges. So as opposed to the current state of play, whereby Eurodac is basically the sidekick of the Dublin system, now it becomes a multi-purpose database that will be used beyond asylum purposes, also for resettlement, for humanitarian admission, for return purposes and law enforcement, especially law enforcement, which has been an ancillary purpose. The conditions of access are simplified in the sense that there are a little bit less more streamlined, and that makes law enforcement no longer such an ancillary purpose of the system. In terms of the personal scope, things also change because it magnifies in different respects. First of all, the fingerprinting threshold is lowered from 14 years to 6 years. And there is also mandatory registration of irregular migrants, plus new categories of individuals, those who are subject to an admission procedure under EU resettlement or national resettlement schemes, plus there is a distinction of individuals who are subject to a search and rescue operation. This means that currently they are being categorized as probably irregular migrants apprehended at the border. Now there's going to be a distinction as to whether these have been subject rescuees from a search and rescue operation. Also, beneficiaries of temporary protection will be subject to Eurodac rules. This excludes Ukrainian nationals who are already registered in a separate repository at EU level. But this is just one part of the change, because it doesn't change only from the perspective of the personal scope, but also from the perspective of the categories of personal data. So there we can identify a key pathway dependency with the other large-scale IT systems, because now that Eurodac is not going to be just a fingerprint database, even the name is no longer going to be relevant, and it's going to be a database which is going to store additional categories of personal data, including facial images, so a second biometric identifier, and copies of travel documents to assist in returning failed asylum applicants. Plus, there's going to be also storing of an assessment as to whether the individual poses a threat to security, for instance, if they are suspected of a terrorist offense or they are armed and violent. The retention period is also modified. For irregular border crossers and irregular migrants is now from 2 years, 5 years. For individuals on an admission procedure, 3 to 5 years, depending on whether they are subject to an EU resettlement admission or a national admission scheme. And for beneficiaries of temporary protection, is going to be 1 year renewable. Because Eurodac is now going to be a multi-purpose database that will be used for return purposes, now transfers to third countries are feasible, are going to be possible for the purpose of effecting return operations. Mostly the good thing of this regulation is actually that the right to information of individuals is heavily strengthened to provide more information in a way that's going to be understandable, even it can be in not only in writing, but where necessary also orally, and especially for minors, there are additional safeguards. So what does it mean in terms of protection of fundamental rights? Eurodac has been primarily associated with processing of personal data, and concerns have primarily focused on privacy and data protection. But perhaps already you can appreciate that the new Eurodac rules go beyond those rights. They could affect also right to human dignity, and I will explain how, plus the prohibition of non-refoulement. What is very evident by the multi-purpose nature of Eurodac is a growing blurring of the distinction between different distinct areas of the area of freedom, security, and justice, not only between asylum and law enforcement, as was in 2013, but also with migration, internal security, and police cooperation. The simplification of law enforcement conditions is testament to this assimilation of different groups of third country nationals as security threats. Apart from this blurring of distinction, which is particularly problematic, there is the additional categories of personal data raise concerns about deepening the surveillance towards asylum seekers and migrants, but at the same time will allow for higher accuracy in identifying them. So there is a plus side and a negative side. But at the same time, there are issues regarding the reliability of facial images and of fingerprints as regards minors. There is research that says that we are getting better in accuracy of facial images, but it is also clear that as a minor changes, these characteristics will also change, and that will affect the accuracy of the personal data stored in Eurodac, especially considering the long retention period. At the same time, experience from other large-scale IT systems demonstrates that the more data are stored, the more errors are going to happen. So we cannot be sure that actually there's going to be higher accuracy. They may actually, in fact, be more error rates, as is the case with CIS and VIS. Another thing that poses significant concerns is the security flag that's going to be added, that is going to have long-lasting effects and may affect the application for international protection. Because a security flag is going to be an assessment that is going to take place on the spot, and it's going to be, we don't know whether it's going to be a tick box exercise or there's going to be a free text box whereby more information is going to be provided, and therefore implementation at national level may be problematic. Finally, as regards the data, it goes beyond data protection. There are significant concerns about the right to human dignity because coercion in processing biometric data and recording them is not prohibited, not even for children. There is an exception, but at the same time, the law says if national law permits, then this can be done. So it is not really an exception. There are a couple of last points that I wanted to say. One has to do with right to information, which, as I said, it is indeed strengthened. But at the same time, we have to keep in mind that individuals that maybe provide information doesn't mean that they actually understand it. But there is no requirement to ensure that individuals have actually understood the information that they have been provided, which is a prerequisite for exercising other data protection rights. At the same time, individuals who are now registered in Eurodac and will not know about the future uses of their data will still have their data processed under the new Eurodac rules. This creates already a major information creep, as I call it. Finally, there is an issue with the transfers to countries where the level of data protection is not going to be accurate. And beyond that, what will happen to individuals whose data are being transferred to those countries? And finally, something that I haven't mentioned is that all this data is going to also generate a series of statistical data. There is more than 3 pages in the Eurodac regulation with requirements for creating many statistical data that presumably are going to inform policymaking. Yes, that's one part of the story, but at the same time, it doesn't say how they're going to inform policymaking. For instance, we could presume that the statistical data will be used in order to create algorithms that are going to detect patterns of flows in order to be used for predictive migration tools. And therefore, this evidence policymaking may lead to more coercion, more unlawful practices at the borders. I think I've said enough. There are a couple of good things in the Eurodac regulation, but overall we see that this transformation, which has been in the making for basically more than 8 years, raises a lot of human rights concerns, which go beyond the mere technical rights of data protection and privacy. Thank you so much for your attention. I look forward to your comments.
So, thank you so much, Professor for this very interesting presentation that has shown the novelties and broadening of the scope of the Eurodac, new Eurodac, and the problems associated with compliance with fundamental rights. So now I give the floor to my colleague, Professor Iris Golden-Lang, who is a distinguished scholar from the University of Zagreb and that maybe will try to answer the question, human rights monitoring effective or window dressing? The question. Thank you. The floor is yours.
Thank you. Thank you so much. And a big thank you, of course, to Philippe for the invitation and for organizing this and many other very diverse and rich Odysseus activities, as always. So my plan for the next 15 minutes is to talk about the establishment of national independent monitoring mechanisms, as I will explain later on. They are planned also as part of the novelties introduced by the Migration Pact. Before that, I would like to point out two kind of major issues related to the establishment of these mechanisms. First of all, I would like to point out that they will have a rather limited mandate, and I will talk more about it later on, but these are the two main points that I want you to get out of this presentation. So the limited mandate will mean that they will not cover border surveillance, which is the likely time when most violations actually take place. So it's a challenge, it's a problem. And I think that this limited mandate, which does not cover border surveillance, is due to the fact that the establishment of these mechanisms is a kind of a reflection of the existing conflict between two very diverse European policy objectives. On the one hand, there is the official policy objective to prevent irregular migration, plus the unofficial policy objective to reduce asylum applications, which go together. And on the other side, conflicting to that, we have the EU values and principles. We have a ban on violent treatment of third country nationals. So, you know, these two conflicting objectives kind of put together what we do have the establishment and monitoring mechanisms, but with this limited mandate. The second point that I would like to transmit to you is that it's very difficult to say in advance how effective they will be. And I will try to explain that there are a number of conditions and factors that will impact their effectiveness in practice. What I think is one of the main points is that there is a need for EU-level harmonization of their methodologies, and I will explain what it means later on. Now, let me first briefly show you what the screening regulation says about these mechanisms. So Article 10, paragraph 2 of the screening regulation states that each member state shall provide or establish an independent monitoring mechanism which shall monitor compliance with union and international law, including the Charter, in particular as regards access to the asylum procedure, the principle of non-refoulement, the best interest of the child, and the relevant rules on detention during the screening. So there is a very clear reference that it's all linked to screening, and that they shall also, these mechanisms shall also trigger investigations into allegations of failure to respect fundamental rights and monitor the progress of such investigations. And I will come back to that as well. So that's the screening regulation. On top of that, we have Article 43, paragraph 4 of the Asylum Procedures Regulation, which links these mechanisms with border procedures and states that each member state shall provide for a monitoring of fundamental rights mechanism in relation to the border procedure that meets the criteria set out in the screening regulation. And interestingly, this did not exist at the early stage of the negotiations of the Migration Pact. So in the early stage, the intended monitoring was only connected to screening. Luckily, at a later stage, monitoring of border procedures was also included. So now we do definitely have the obligation of member states to monitor with these new mechanisms, both screening procedures and border procedures. So the limited mandate, I come back to that, refers to, on the one hand, the geographic limitation. So as we know, border procedures take place at the borders. Screening mostly takes place at the borders, not always, but in most cases. So the mechanism's work will be mostly confined to the EU's borders, primarily EU's external borders, I would say, but not only external borders. And there is a functional limitation that I've mentioned before, that if you look at the text of these regulations, only screening and border procedures are included, no border surveillance and no border checks, which is a problem, definitely, because border surveillance is something that should be monitored. There are other national and international and European mechanisms checking what's happening during border surveillance, but I think that this is a kind of a wasted opportunity. It's a pity that such new national monitoring mechanisms do not include also border surveillance. And this is, of course, due to the member states' reluctance to strengthen the monitoring of their border surveillance. Now, there is a but, which will depend on the creativity, on the one hand, of the judiciary, and second, on the willingness of EU member states to expand the competencies of these mechanisms. As regards the potential creativity of the judiciary, if you look again at Article 10.2 of the screening regulation, it states that independent monitoring mechanisms shall cover all activities undertaken by the member states in implementing this regulation. So the big question is, how do you interpret the word implement? You can read it narrowly and more extensively. If you decide to read it more creatively, more extensively, you could say that then in that case, monitoring applies to any activity which is indirectly linked to screening. As I said, this is a very creative, extensive interpretation. And then maybe you could also say that there is the obligation to apply the charter not only to the monitoring itself, but also to all the monitors' activity, all the activities that are being monitored. Yeah, because that's also included in the monitoring. I think that the likelihood that this is going to interpret it this way is not significant. However, as I said, there is a potential for EU member states to expand the competences of these mechanisms. And this is also something that's suggested by the guidance of the Fundamental Rights Agency that I'm sure Tamas will talk about more later on. So, again, in Article 10.2 of the screening regulation, it stated that the Fundamental Rights Agency shall issue general guidance for member states on the establishment of a monitoring mechanism and its independent functioning. And such guidance has been issued. And all the activities, it states explicitly that what is subject to monitoring is screening, all the activities related to screening. Second, all the activities related to border procedures. And third, that member states may decide to extend the mechanism to cover related border management activities, including border surveillance and/or return border procedures. So they may, but they need not to. This is just a potential, and it's, of course, up to the member state to choose whether it will use this potential. Apart from this, there are several challenges related to the efficiency of the mechanisms that I would like to mention. First of all, I think that the efficiency of the mechanisms will primarily depend on human and other capacities of these mechanisms and the number of checks. So the likelihood of spotting any violation is higher if you have 100 checks, 100 monitoring activities in comparison to 20 per year, and so on. So the more capacities these mechanisms have, both financial and operational, the more likely are they to be efficient. The limited capacities of these mechanisms could partly be compensated in case they are given access to national police information systems. Okay? And I think this is really, really important. And also, if they are given access to pending cases before national ministries. This is not regulated. So there is nothing mentioned about having access to national information systems, national police information systems. So what we might end up with is having disparities among member states. Member state A having a mechanism which has access to such information systems, which then enlarges the chances of noticing some irregularities and dealing with them, where member states B does not grant such access. And of course, also having differences in terms of their capacities, financial and operational capacities. So in the end, you might end up with having different mechanisms in practice in terms of their methodologies of work and procedural rules. And due to that, I think it's really, really important to establish EU-level methodologies of evidence gathering and processing. And this is, again, something that's a possibility. So, again, according to Article 10.2 of the Screening Regulation, member states may request the Fundamental Rights Agency to support them in monitoring methodology. But they must not, they need not do it. So, some may do it, some may not do it. As a consequence, you might end up with having very diverse and unreliable and incomparable data. Because if monitoring mechanism A uses one methodology and monitoring mechanism B uses a different methodology, the data that you have is not really comparable at the EU level. And then finally, and these are the last points that I want to make before I conclude, I just put down the must-haves of these mechanisms, and then I put the checks where these must-haves are satisfied. So they need to have the ability to do spot checks and random and unannounced visits. It's very important that they can do unannounced visits, and they can do it based on the screening regulation. They need to have access to all documents, places, and individuals. They do, but as I said, there is no mention of having access to national police information systems, which is a kind of a gap, I would say. They need to have adequate human and financial resources. Again, something that is stipulated by the screening regulation. Very important, they need to have independence in law and in practice. Again, something stipulated by the screening regulation. And I think it's really important that this independence is understood broadly, not covering only independence at the moment when the mechanism is being established in terms of its composition and so on, but also throughout its work, so that it has financial and operational autonomy throughout its existence. They need to issue reports and recommendations. Here I see a problem because according to the rules, they have the power to issue annual recommendations. They have the power. Does it mean that they have to issue recommendations? I'm not that sure. And if they don't issue recommendation, I think their very reason of existence is questionable, because they definitely should issue reports and recommendations. So I think it could have been said more explicitly and made more kind of as a kind of a commitment. Additionally, they should have the power to request state prosecution authorities to launch investigation in case they notice that something is done wrongly, so that there is a violation or any type of irregularity. As I mentioned at the start, the screening regulation says that they shall trigger investigations in case of violations. But it's not really clear what is meant by that. Does it mean that they must request state authorities to launch investigations? Or what is meant by the words trigger investigations, and who does the investigations? And finally, again, an issue that is not covered, it seems to be, there need to be follow-up procedures in case of violations, and there need to be follow-up procedures once recommendations are being issued, right? So if you have recommendations saying that something is wrong, that there has been a violation, then there needs to be an action on the side of the member state to try to correct that violation. So there should be EU level rules in terms of follow-up procedures and follow-up of these recommendations. To conclude, what is the purpose or also the effect of these mechanisms? I would say that they have dual purpose and hopefully dual effects. First, they have the deterrent effect, or they should have the deterrent effect, that their mere existence and the fact that they do the monitoring should have an effect on national authorities to deal in the process of screening and in the process of border procedures more carefully with individual rights. And they should also have a corrective effect. Now, the question here is whether we can expect these mechanisms to, in terms of their corrective effect, to be more likely to spot systemic deficiencies in screening and border procedures, or to spot individual violations. I would personally think that they are more likely to spot systemic deficiencies because, you know, to spot individual violations, you need to do a lot of checks, and especially if you have limited capacities then to spot individual violations, the question is how successful you will be in spotting those. And then finally, the question is at the national level, who will be these mechanisms? Member states have the power to choose whether these will be newly established bodies at the national level, whether this will be done by national ombudsperson's offices or somebody third. And hopefully we will know more about it based on the national implementation plans that should be submitted by the end of this year, but we have to wait and see. Thank you very much.
Thank you very much, Professor Lang. So we have understood that the system has potential effects, but we will understand the effectiveness of the new mechanism only in the implementation phase. But if I quote correctly, the margin of discretion which is left to member states may cause important differences in their national practices. So the role of the agency is very important in that regard. So now we are going to the common phase. So I don't see Grigoris Tsioukas.
So I'm here. I don't know if you can hear me. I'm online.
Is online. Okay.
Okay, can you hear me?
Yes, very well.
Okay,
So I
great.
give the floor to Mr. Tsioukas, who is Deputy Fundamental Rights Officer at Frontex. So please, Mr. Tsioukas,
Hello.
the floor is yours.
Hello. Sorry that I cannot be there with you. I'm joining from Romania right now, where we are having some training. Actually, it is a training addressed to monitors working for the Fundamental Rights Office, where we try also to understand the operational or the modus operandi of national authorities, and I think that this is important also for the future national monitoring mechanism. In order to be able to assess what you see, it is important that you have a good knowledge of what are the operational activities and how the operators in the field work. So I'm really sorry that I could not be there with you, but I'm very much honored for the invitation. I understand that I have a few minutes at my disposal to provide some comments. I will focus my comments on what Iris was she was just presenting, but before going to national monitoring mechanisms or to the monitoring, let's say, landscape under the new pact, allow me to say a couple of words as regards the screening regulation. And I wanted to stress a couple of points which I consider to be as positive steps. The first and probably the most, not the most important, but the first is because I consider as the most important the creation of national monitoring mechanism, but I will come back to this later. So the first point is that we will have now a uniform procedure in every external EU border, which is not the case so far. So far, what we have seen, and I base now my comments on field observations, what we have seen is that different member states, they apply different procedures. In some cases, procedures differ even by location. So in the same member states, you might have different screening procedures depending on the location. So I consider this to be a very positive development because this will also help us to establish some common standards and to try to improve the standards to be implemented in the future. Second, this will allow also to have common training for the standing corps officers and the border guards, the national officers who will be dealing with that particular activity. And the third point is that finally we have identification of vulnerabilities as part of the screening process by default and as a standard operation, which, according again to our experience, has not been the case so far, not everywhere. So these are three positive elements that I would like to stress, and now I'm coming back to the core of my intervention, which is the establishment of monitoring mechanisms. Here I represent the Fundamental Rights Office of Frontex, and this is monitoring is what we do in the context of Frontex operational activities. Earlier, Iris was referring to limitations of future monitoring, national monitoring mechanisms. Here, I would like to stress the limitations of the Fundamental Rights Office. Those limitations, they derive from the Frontex regulation, and they relate to the fact that not all activities at the borders are Frontex activities. In other words, we do not have the possibility to monitor national screening procedures. We don't have the possibility to monitor national debriefing procedures. We don't have the possibility to monitor national surveillance activities. So there is a need for complementarity here. Yes, we can ensure from our side that Frontex activities keep up to certain standards, but when it comes to activities performed by national authorities, I'm afraid that we cannot easily reach that point. What do we need for that? We certainly need the establishment of national monitoring mechanisms. Of course, the screening regulation here is highlighted this point, rightfully so, is limiting the monitoring mandate of future monitoring mechanisms to screening procedures. However, I believe that when you witness screening procedures, what you see is people talking on the basis of questions that they receive, talking to some police officers or border guards, and there they quite often, and it happens to us as well, when our monitors are present during such procedures, people, they might talk about experience that they had while trying to cross the border. And it is the case that that sometimes they might be also referring to violence that they might have experienced in the past, or when they cross the border, or experiences of refoulement. So a question for me is, if you are witnessing, if you listen to such an account and you are representing a national monitoring mechanism, do you have any options? What will be your assessment? Will it be that this is not relevant to the screening procedure, so I'm not mandated to forward with an investigation about what I just heard? I would say that this would be a very limited interpretation of your mandate. In other words, maybe we can use the new possibilities of the screening regulation in order to expand the mandate of indirectly the mandate of the national monitoring mechanisms, which are foreseen for screening procedures, to cover also border surveillance, not because the monitoring or the national monitor is present during a border surveillance activities, because the monitor is witnessing an account by a person, by an individual that has been through a process at the borders which raises fundamental rights concerns. I hope that it is clear what I'm trying to say. I'm trying to see or to interpret the current or the future mandate in a way to cover what now is missing. And this is the first point that I wanted to make. The second is that, as I was saying earlier, it's very important to establish those monitoring mechanisms, because in that way we will have a more comprehensive monitoring system, with Frontex Fundamental Rights Office covering and monitoring Frontex activities, and national monitoring mechanisms covering national activities, either directly during the screening, when whatever is related to screening, but also indirectly through what I was trying to explain earlier, through investigations that could be triggered on the basis of accounts of people who are going through screening procedures. So this is the way to go in order to ensure a more comprehensive monitoring system in the European Union. This would require also coordination between the national mechanisms and the EU mechanisms like the Fundamental Rights Office, but also the Fundamental Rights Officer of EU UAA, I would say, as well as the Fundamental Rights Officer of Europol. So at some point, we need to discuss how we bring together all those mechanisms and how we coordinate their work. We are not yet there. From our side, we are making efforts to create a platform where we could be discussing all those issues in the future, but more needs to be done. And the last point, and sorry for taking more time than it was allocated for me, I think that whenever we have national monitoring, national human rights bodies which are effective and they have expertise and experience, I think it is in the benefit of efficient and effective monitoring, to make use of those mechanisms instead of establishing new structures which would take more and more time to establish their operational methods and to start being effective in the field. Of course, human resources are important as well as funding. And I will stop here at your disposal for any questions you may have. Thank you.
So thank you to Mr. Tsioukas for pointing out on the role of Frontex in the new pact. So now I give the floor to the last speaker of this conference, Dr. Tamás Molnár from the Agency for Fundamental Rights. So, Mr. Molnár, the floor is yours.
All right. Good afternoon, everyone. It's already afternoon. And first and foremost, I would like to express my deep gratitude to Philip and the organizers for having invited me to this high-octane event discussing the different ramifications from the legal perspective of the instruments adopted under the new EU Pact on Migration and Asylum. I know my challenges. I mean, I'm the last speaker of this 1.5 days long, fully packed, interesting and informative day of discussions. Everyone may have been exhausted by that time. So I'll try to, even if not saving the best for the last, but at least being meaningful and to share a few comments relating to the previous two speakers on Eurodac and the fundamental rights implications and challenges, and at the same time, more generally, of the new monitoring mechanisms under the pact. And having said that, what my reflections will also be linked as much as I can to the work of the Fundamental Rights Agency on these respective matters. So I may sound at certain points like a vacuum cleaner agent of, doing a shameless self-promotion of the agency and our materials. Well, let's start first with this odd creature, this underdog of the EU legal edifice on asylum, namely Eurodac. A few reflections on Eurodac. I mean, the significant fundamental rights implications going beyond data protection and the right to privacy have been eloquently highlighted, underscored by Niovi in her talk. I just would like to mention that the Fundamental Rights Agency has also looked into that back in the time at the end of 2016 when we produced a legal opinion on the fundamental rights implications of the 2016 proposal, which is by and large the basis for the new rules that was the legal instruments further developed. And we also found that the original proposal and still the adopted version impact significantly on the rights of the child, on the right to asylum by the data transfers to third countries, as well as human dignity, right to liberty, and it can also lead to arbitrary deprivation of liberty. So it's a larger package when it comes to fundamental rights implications, as one would think at first sight. And around that time, we produced something which is like a checklist of how to take fingerprints for Eurodac in a fundamental rights compliant manner. And this FRA checklist was also referenced in one recital of the new Eurodac regulation. So in a way, it's a small thing, but we are happy with this reference to a FRA guidance, which should then guide further member states' action when taking fingerprints for Eurodac purposes. And another thing, and here again, my vacuum cleaner agent self comes to the fore, we also produced a leaflet on the right to information to guide authorities dealing with Eurodac registrations, how to inform all people concerned in a fundamental rights compliant manner. Here you go, ladies and gentlemen. And these petits machins are also available outside in the foyer. I've put them on the table, first come, first serve, if there's any remaining. And just to enlarge a bit the scope and to talk about EU large-scale IT systems and the fundamental rights implications, I think this should be the new black, since us lawyers, and maybe I'm wrong, but I just then challenge you or provoke you, I think we have substandard knowledge on all the fundamental rights considerations, implications, and impact of the EU large-scale EU IT systems in depth. We have some exceptions. The exception, like Professor Vavula, strengthens the rule, but I think there's room for improvement in this regard. And it's key to raise awareness about those fundamental rights, just the functioning of those IT systems and also the related fundamental rights concerns. And to help remedy this gap, the agency will soon produce, or it's rather publish, an online tool called Awareness Raising Tool on the fundamental rights implications of all these EU large-scale IT systems, including Eurodac, SIS, VIS, and the list goes on. So it will be out online in December. Stay tuned. Then that was Eurodac. And now I move to monitoring more in general. The first thing is that, of course, monitoring fundamental rights compliance is a classic and key human rights tool used at national and international levels, especially in those areas where the public has no or limited access, in remote areas, in detention facilities, or at the border. And there is a lot of experience gathered in the UN and the Council of Europe system, as well as at national level, for instance, by the national preventive mechanisms in this regard. And the big challenge under this new landscape of the PACT monitoring is to apply the lessons learned from decades of fundamental rights monitoring in those classic settings to these new systems of monitoring mechanisms in the context of screening and the asylum border procedure. Since it's different, and one has to bear in mind the complexities of just the screening procedure. Sorry, it's not even a procedure, of screening tout court. And as you know, it was mentioned, FRA has recently published, again, vacuum cleaner agent, our new guidance on setting up independent national monitoring mechanisms in the context of screening and asylum procedure. It is now only available in English, but more language translations will follow by the end of by the beginning of next year. I'm not gonna talk you through the 9 building blocks of this guidance. Some copies again are in the foyer. In the Gutenberg Galaxy form, and it's also, of course, free of charge downloadable from FRA's website. Please consult. I just would like to focus now in the remaining 4 minutes on the operationalization, how to make sure that now it's out there. It should, of course, speak for itself and should guide member states' actions, but efforts are needed, proactive efforts to make it a reality, to make a change out there in the next 1.5 years until the entry into force of all the new instruments, including the monitoring duty. we have already, as the agency, started engagement with member states, both with the national authorities like ministries and also with national human rights institutions, either bilaterally or multilaterally, like in the form under the umbrella of the ENRI Forum. This is the European Network of National Human Rights Institutions. And so far, what we have seen and what we think it's important to convey is three things. The first is that the screening regulation requires that independent human rights statutory bodies like ombuds institutions, national human rights institutions, or NPMs participate somehow in the monitoring system. They should be part of the design. And we suggest that where feasible in practice, it is the most effective to designate such independent statutory human rights bodies for the monitoring under the pact, since they have already the expertise and institutional memory. It's the most cost effective, and it avoids the fragmentation of human rights monitoring actors. Then the second thing is funding and its relation to their independence, to such mechanisms' independence. Since funding of the monitoring mechanism must be compatible with the principle of their independence, and it's based on our discussions and consultations, it came up quite significantly in the context of the role of EU funding. Since EU funding could be or should be available, this is also something we argue in our guidance, but it needs to be used to find a way not to lead. I mean, using EU funds shouldn't lead to real or perceived risks of threatening such bodies' independence, since the national envelopes under the AMIF and the BMVI funds are typically managed by the same ministry responsible for implementing the screening or the asylum border procedure. So we need to explore better what flexibility exists to address this issue. And the new MFF, the new multi-annual financial framework, will soon begin. So when the AMIF and BMVI instruments are revised, this should also be kept in mind to find a way for a direct EU funding of monitoring mechanisms without the, let's say, intermediary of ministries as managing authorities. The third thing is that to ensure that monitoring findings also have an EU added value. And here I very much, let's say, echo what Professor Golder-Lang has just said. Since classical monitoring mechanisms are usually looked at the national level and they produce country reports, fine. But these new mechanisms should be designed in a way that they can inform not only the national processes, but also the EU processes. So the findings need to be available at right time and in a coherent way so that they can feed into the drafting of this new EU migration paperwork, all these EU strategic asylum and migration documents, then the Schengen evaluation and monitoring mechanism, Frontex vulnerability assessment, or the EUAA monitoring mechanism alike. So this convergence requires working on common EU harmonized monitoring methodologies, aligned reporting tools, and also aligned timing of producing the reports to make sure they are timely and they can feed into those EU level processes. The legal basis there in the screening regulation may be requested by member states. So of course we encourage member states to reach out to us. And we are ready to start a so-called Vienna facilitating process, pun intended, and sorry for the bad word joke. And the last comment, and I've stopped there, relates to the scope of the monitoring. And this has also been picked up by the previous speakers, especially Professor Golder-Lang. The first thing is indeed border surveillance should be in, this is something that's missing, and in the guidance FRA argues and advises member states to extend it to border surveillance, especially where it's appropriate and adequate, taken into account the national circumstances and the operational realities. I think this is the language in all of the points in our new guidance. And the second one, this is the return border procedure, which is the parent pauvre. It's a bit forgotten out of the equation, and there's no corresponding monitoring mechanism during the return border procedure. It may be the case due to the last-minute decoupling of this from the APR, and they just forgot, and maybe it's an oversight. No matter what, there's at least one kind of monitoring obligation. If we read jointly the return border procedure regulation, it's Article 4, Para 3, together with the return directive, then the joint reading leads us to the conclusion that the forced return monitoring systems should also apply in the context of the return border procedure. But of course, actually monitoring the concrete removal, forcible transportation of people out of those border areas to the third country is just one small slice of the whole cake called return border procedures. So definitely there should be a need to include it also into this seamless set of procedures carried out at the border where the legal fiction of non-entry applies. Maybe the EU legislature will find a way to remedy this omission. The topic is huge. My time is over. I stop here. Thanks for your kind attention.
So many thanks, Dr. Molnar, for your comments and for letting us know the many materials that the agency has already published and will publish soon in this regard. So now the time is for the questions. So we start with, as usual, from online questions. Is there any questions? Yes.
Just a reminder for all the followers that are online, please turn on your camera and your mic. Mr. Richard? Ms. Blandine, you have your hands up. Do you have also a question up? You are muted. We cannot hear you. Can you please turn on the camera and unmute your phone? We can pass to another question. Meantime, apparently she have a technical issue. We have a question in the room, meantime.
Hello, my name is Joseph. I'm a social worker based in Brussels, but I've also had experience on the ground at the EU's external borders. So I talk from that perspective. When you were talking about monitoring, I really appreciated the presentation, and I of course agree with the notion that it should be expanded to all factors of the process as much as possible. But I think there is a more fundamental problem that is not discussed and which is very present in reality, is that despite everything that is put in place, there is a serious power imbalance in the monitoring, where the agencies collaborate with also the administration or the law enforcement that is often implicated in human rights violations, and that the other side, the stories of the people affected, are not accounted for in the same way, sometimes because they are not present, because they have been a victim of refoulement. And so for me, I think we can be honest on the fact that there is a lot more violence and violations that happen at the border that are being reported. I think everyone also knows this. And I find it not so serious also what the person from the intervention from the person from Frontex said, that we have everything handled with Frontex activities, we just need this expansion, while this is simply not true. And there's been a lot of reports of, for example, a lot of human rights violations happening where by national guards, where Frontex was present or Frontex at least had information, and this was not reported because there is this power imbalance in not wanting to incriminate national law enforcement, or sometimes not wanting to incriminate, in the case of Frontex itself and their participation. So for me, I have a bit of skepticism in the real effectiveness of this kind of monitoring mechanism on the ground when this reality that already exists today is not addressed, and I don't see how it will be any different.
Thank you. There is a question from Professor Skardas here. Okay.
Last time you can unmute that microphone and you don't. Okay. Technical support, can you please try to unmute it? No? Okay.
Thank you very much for your presentations, which were really very informative and very critical. I have one comment and one question, and they are the comment is linked not only to this panel, but it's more general, but I wanted to put it at the end of our discussion. We have spoken long about the values of the Union on all possible contexts. But if we take a look at the Treaty of the European Union, the situation is less clear because the treaty speaks about values and interests, in particular in the international context. Let's take a look at Article 3, Paragraph 5, or 21, Paragraph 2A. So there was the old theory of union as a normative power. This is passé. We are in a period of the union as a realist power and perhaps as a geopolitical power, as von der Leyen has said since her first commission. So we need to consider these aspects when we try to understand or interpret law as well. My second question has to do with the fundamental rights officers in the Frontex. And here I don't want to be misunderstood. I'm fully aware that the people who work in as fundamental rights officers, they have a very good knowledge. They're experts in human rights law. They may have also good knowledge of international law or of other aspects of law. However, the general practice with it's a global practice. It's not just European for military or police bodies is that there are there is a group, an office of legal officers. There are the US Army, the Greek Army. I was providing legal advice when I did my military service. So why human rights officers and not legal officers working within the Frontex? And the question is that I have the feeling that the mandates of a human rights officer and of the Frontex are in a certain tension. Despite the efforts that we make to harmonize them, there are real tensions there. And I wonder why it would be necessary to have this very unique structure, in particular in the European Union system. Thank you.
Thank you all for your presentations. I have a question for three of the speakers, so Iris Goldner, Lang, Gregorios Tsoukas, and Tamas Molnar. So You mentioned also in your presentations that these national mechanisms come into a kind of complex constellation of already existing monitoring mechanisms. So the vulnerability assessment of Frontex, the Schengen evaluation and monitoring mechanism. The Agency on Asylum is meant also now to have a monitoring mechanism. So we understand on the normative level that it is good that there are synergies between these mechanisms, but I wanted to ask you practically, are you aware whether there are these synergies on the ground already from the existing EU level mechanisms? And if there are, what these are? And also very practically, which are the very concrete avenues that these national now independent monitoring mechanisms can feed into the existing monitoring exercises? Thank you.
Thanks for organizing all the event and for all the people who intervened. My name is Tom Montel. I'm a PhD student. I have a technical question to Niobe Vavola about the category 2 Eurodac data. I never understood what was the rationale with the fact that category 2 data are kept for 18 months, while responsibility of the first member state of entry is 12 months. And I see that the difference is also increased with the new Eurodac regulation, since the category 2 data will be kept for 5 years. And the responsibility is, if I'm not wrong, maximum 2 years or 15 months. I have a doubt. Anyway, could you please explain what is the rationale of keeping those data longer and why, what it will be used for? And maybe I also precise that when responsibility is determined, the 12 months rule doesn't work anymore. Will the fact that responsibility has been determined be registered in the Eurodac? For instance, someone moving to a second member state during the 12 months and having a determination procedure concluded in the second member state. And then I have a question about the category 3 data. Could you please confirm that member states authorities will not be able technically and authorized anymore to check what is in the Eurodac without registering fingerprints of people apprehended while staying irregularly on the territory of the national member state? Thanks.
We start in the room to answer this question, and then we give the floor to Mr. Tsioukas, who has a lot of questions in relation to Frontex.
Okay, I will start with the more technical questions. So basically, indeed, I have also argued that with regard to irregular border crossers, the retention period of 2 years at the beginning and then 18 months wasn't disproportionate. Now it has moved to 5 years because the data are not going to just be used for asylum purposes, but also for return purposes. So essentially an added new purpose, which we can debate whether it is a primary or an ancillary purpose of the database, actually determines how long the data is going to be kept. So the rationale has been wrongly implemented with a disproportionate retention period at the beginning. Now it is extended on the basis of the additional purposes for which Eurodac is going to be used. And as regards category 3, it is mandatory to register irregular migrants found on national territory and to consult the database in order to see whether they have already applied for international protection elsewhere. So category 3 now becomes mandatory, which is interesting because if we see the statistical data from EU-LISA, we will see that actually member states were using that category, even though it was not mandatory, quite a lot. And 25% of the data involved irregular migrants found on national territory. I would also like, if I can have 30 seconds to answer on Professor Skondra's comment about these values and interest issue. I'm with you. In the existence of a legitimate interest legitimizes action, but at the same time, we need to take into account that the existence of legitimate purpose doesn't mean that we shouldn't do a fundamental rights check on the basis of the base proportionality. So proportionality is going to determine exactly that, whether our values and interests actually correspond with the output. And at least in what I see in digitalization, we see very much emphasis on the interests, especially security, under this broad banner, which includes everything, at the expense of fundamental rights protection, which go much beyond data protection. Thank you.
Yeah, as regards the first question and the comment that there are many more violations at the border than are actually being spotted and reacted to, I'm sure you are right, because the question is how much can you actually see, how much can you report? So, and how likely are you, no matter whether we are talking about the already existing mechanisms or the new ones, to actually spot something, by sitting somewhere in the woods or, hidden behind a bush. So there is, of course, the likelihood increases the more capacities you have, the more checks you do, the more frequent checks you do, and the more people you have, the more human resources you have, the more likely are you to notice any types of violations. So that's why I think it's really important that this obligation to invest adequate financial and operational resources into these new mechanisms is actually taken seriously by member states. And I do agree that EU money should be used, and I absolutely agree with Tamás's point that it should be used in such a way that there isn't this relationship of dependence on national ministries, which is problematic because EU money comes to state authorities. So how do you actually do it? And also, with regard to your point, I think that's why it's more likely that systemic deficiencies will be noticed. Because if something is being done in an incorrect, human rights incompliant manner, in a systematic manner, then it's more likely to be spotted. So I think that's more of an added value of these mechanisms. And that's why I really think also it's important to have access to information systems of the police. Because then, even if you don't spot something with your own eyes, probably it's there somewhere recorded or somehow put on paper or in the electronic form. And as regards Lillian's question on synergies and how these synergies might come into play with the establishment of new mechanisms, I think there are basically three possibilities. So one possibility, and before I say what the three possibilities are, there is an explicit obligation for these synergies provided in the screening regulation. So there it's explicitly mentioned that in Article 10, that national ombudsperson's offices and other national and European bodies who are there to protect human rights should be involved in the work of national mechanisms. So there is an explicit obligation to do that. How can you do it? You can involve them, for example, as members of advisory boards of these national mechanisms. This has been used in the Croatian pilot project on national monitoring mechanism, where we had both the Fundamental Rights Office of Frontex involved, the European Union Asylum Agency involved, the Ombudsperson's Office of the Republic of Croatia involved, UNHCR in Croatia involved, and so on. So they can be involved as members of the advisory board. That's probably the weakest possibility. Then there is the second stage where you could say, well, you could have these national bodies as part of the future mechanism. So you could maybe arrange it, legally speaking, to have national ombudsperson's offices as part of national mechanisms, but not only in the capacity of advisors, but as active members in the coordinating board or something like that. And the third possibility would be to have something that has been mentioned by Tamás, I think, to have national mechanisms as one of the elements of national ombudsperson's offices or national offices dealing with these types of monitoring already. So it depends how national authorities see the best way, the fittest way to do it. It's currently they have the power to choose.
So starting with Joseph's first question, the power imbalance. Is it on now? Yeah. All right. So thank you. And starting with Joseph's question on the power imbalances in monitoring and there are more violations than reported. Indeed, that's the case. It's impossible to see every single unlawful action on the ground. And I mean, that's why risk assessment is also important. So the monitoring entities should go to places and locations and situations where, based on a thorough risk assessment, there's a higher likelihood of seeing something. And it was also mentioned by Iris that it's better, the goal is better to spot systemic violations or individual violations. And even by covering a number of violations, which can be said it's the tip of the iceberg, can of course inform the observer, the monitors, about more systematic features, problems, and then if it's then goes into findings and is followed up, it can remedy the situation. I think monitoring, it's just virtually impossible to look into every single rights violation or to report and record every single rights violation. And monitoring also has a strong preventative role, since if such mechanism is there, authorities in uniforms know that there are watchful eyes, independent watchful eyes looking at what they do in their work, then we are human beings. It has an effect of gently steering them towards rights compliant and lawful action. So the preventative side of monitoring, I think, should also be underscored. And regarding the synergies on the ground, if I understood correctly, I mean, Lilian's question went into, okay, how to make sure that the already existing EU processes, click nicely together, and also seen from the new national mechanisms, how they will make sure that from the national to the European, there's also, so it's both horizontal synergies and vertical synergies, and all these together. Yeah, I would add as a starting point that in the revamped version of the Schengen Evaluation and Monitoring Regulation, there's already a reference, this is black letter law, that the vulnerability assessment, for instance, by Frontex should feed into the preparation and the evidence-based use for Schengen evaluations. It happens. I mean, FRA and I myself, we are part of Schengen evaluation on-site missions in the field of returns and border management. And this is the usual practice of relying on information from these baseline assessments carried out for vulnerability assessment when we prepare for the Cheval missions. And also, following with this practical line, there are joint meetings of the 3 fundamental rights officers currently operating. So the Frontex, the EUAA, and the Europol FROs, Fundamental Rights Officers, meet, and this is facilitated by FRA. So we sit down with them together and discuss topical issues on a regular basis. And also as far as I know, Frontex fundamental rights monitors also joined forces in some national context with already existing forms of human rights monitoring bodies. That was the case in Croatia, if I'm not mistaken, and also in Greece. Since in Greece, yeah, it's an interesting entity. It's not an independent body, but there's a fundamental rights officer sitting in the Ministry of Migration and Asylum. And Frontex fundamental rights monitors went there and with that person also visited the ground and carried out some operational observations. And the last thing, and Pro Futuro, currently Frontex Fundamental Rights Office is also organizing a big event together with FRA and the national human rights institutions on this new monitoring mechanism under the pact. And of course, this is also about finding synergies, how to make sure that future national monitoring mechanisms will work in peace and harmony, like Avery and Ivory living in peace and harmony, just to cite the classic. How to make sure that all these systems will work in the right way without duplications. So yeah, that's it. And also just the last point, FRA has already started discussions with the EU Asylum Agency, given that now they have this monitoring mechanism, at least on paper, out there, and working level technical discussions have started, but the point is valid and will remain valid indeed. Thank you.
And now, Mr. Tsoukas, and the role of Frontex.
Okay, thank you. So my turn. Thanks for the questions. First of all, about violation at the borders. Me too. I have no doubt that many more we have many more violations than those reported at the borders. What I was referring to earlier is that actually we have very few cases of Frontex staff and assets directly involved in such violations. And for me, this is an important element that I want to stress. Indirect involvement of Frontex in such circumstances, yes, I don't doubt that it is the case. But then there is this big question: okay, what Frontex should do when the national authorities they have practices which are against what we have agreed as common practices to be implemented, and practices, obviously, I'm implying here, that are violating rights. Should Frontex stay or should Frontex go? It is the discussion about Article 46, but I'm not entering into this now because then we need another conference to discuss about it. But I want to use the opportunity to answer to the question, okay, is it effective or it is window dressing? And I would say we don't have any other plan than this. We don't have any other plan than having a comprehensive framework of monitoring at the EU level and at the national level. What is missing right now is the national level, and this is what we could see in the future developing, using the opportunities that are there with the new screening regulation, which foresees a limited, of course, mandate for those institutions, but still it is a very positive step, as I said. Now, the second question addressed to me, if I well understand it, is why don't we have legal officers? So, why we refer to human rights monitors and not to, why do we need them in a way, right? Since this this is something, such an activity could be performed better by people who understand legislation, therefore lawyers. Here I want to say that me personally, as part of the management of the office, I very much appreciate the wealth of expertise and experience that we have in the office, and I would not renounce on the possibility to draw on the experience and expertise of people who are not only lawyers but also who have an understanding of policies, an understanding of international relations, people who have an expertise working for many years in the field with non-governmental organizations, but as well as people who have been working in the field as law enforcement officers. So I think this is a good combination of knowledge and expertise that I would definitely like to keep. And in a way, I would like to see also in future monitoring mechanisms. As regards the very last questions on synergies, Thomas already said a few things. From my side, just to add that as a standard procedure, we try, and our staff, when they are in the field, they try to cooperate with the national human rights institutions and ombuds institutions as by default, exchanging information, organizing and providing common trainings to border guards or having common workshops, forwarding. There is a mechanism, probably you are aware, the complaints mechanisms that we are responsible to handle according to the rules of procedure when there is a situation involving national officers, national authorities. The complaint mechanism is transferred by default to the competent, usually ombuds institutions. So in a way, we are already working closely with them. Yes, they are not in the field yet, so we have not, we didn't have so far joint monitoring missions, let's say, but I hope that in the future this will be possible. And here I stop. Thank you.
Is there any final questions? Otherwise, we conclude more or less on time. Okay, so before giving the floor to Philippe, I would like to thank Professor De Brucker and all Judicious team based at ULB, so Lilian, Nicole, and the technical support for organizing this conference, which was perfect on every aspect, and also the Odysseus members, colleagues, and all the speakers. I think we all go back and reach after this fruitful and conference. So, Philippe.
Thank you very much, Alessia. Well, you just thanked all the speakers, the Odysseus colleagues, so I'm not to do this again, even if I really want to warmly thank them. Just let me extend these thanks to the persons who are working backstage. Of course, the administrative team with Nicole Bosmans, who has worked a lot. She's not there in the room for the moment, no. And then also our technical team, who made it possible to have 180 persons online and to have a dialogue between us and them. This team led by Margin, who has also something to say. I will give him the floor because he has something to say. Let me just add before giving him the floor that we will make available on our website the videos of the sessions. and the PowerPoint presentations, and that we intend also to publish a big book about the pact that will be actually the proceedings of this conference in the course of 2025. So, Margin, you will have the last word.
It's been an honor, first of all, being part of this conference. I'm really emotional right now. I'd like to thank you all for all your kind comments, and of course, I can be the face of a wonderful team, but as well we have Marlene, which is there, and for all this IT part of Teams, we have Ledion, which is following and listening and seeing us as well. It's online. For the last part, I liked, since I received a lot of requests from all of you regarding pictures. If you check your email like now, you already received an explanatory email regarding pictures and also links in our social platforms. And as you can see, we have it also in the background from YouTube, Facebook, Instagram, Twitter, and Platform X, LinkedIn, Instagram. Yeah, I mentioned it. So you can check your email. There will be notifications in each one of platforms that suits you the best to use or you can use. And of course, thank you if you like, share, and follow us on our platform. For any kind of concern regarding the pictures that we are about to use on the social platforms, as also in the email it's explained, in case that you have something against, of course, I'm speaking here for all of the participants that were on site. Please email us before we proceed during the next week with publishing the pictures and using them to promote our conference and other activities that Odysseus Network, Academic Network have planned for the future. And me as part of this huge team, I'm really thankful to all of you for your kindness, and it was really a pleasure being here. And thanks to all the panelists that all the time have that precise way of sending all the materials. Without them being so precise, our work wasn't possible as well. So for the participant that probably will be on our summer school of 2025, we are welcoming you. And for those who were in previous editions, we thank you for being here once more. And this is all that I got. Thank you a lot for all your participation.
Thank you. Have a nice weekend. Bye.